Hi, sorry for interrupting. After a break, now our session, which is sponsored by Başgül Law Firm, is going to start. I would like to invite Mr. Erdem Başgül, and other participants will attend online due to the COVID situation. With your applause, I would like to invite Erdem Başgül to the stage.
Hello, everyone. Welcome to the natural gas dispute session of Turkey Arbitration Week. My name is Erdem Başgül. I'm the managing partner of Ankara and Istanbul-based Başgül Attorneys at Law. I feel very privileged to be the moderator of this distinguished panel. I'm grateful to all panelists and Mr. Süleyman Boşça for providing this new law firm with such fantastic opportunity. I would also like to thank Mr. Salih Çayır for his support during the organization of this session. I will start by introducing our panelists. First, Gökhan Yardım is the former general manager and chairman of BOTAŞ. During his time at BOTAŞ, he took part in the preparation, negotiation, execution of natural gas purchase and sale agreements with Russia, Iran, Azerbaijan, Turkmenistan, Egypt, Algeria, and Nigeria. He then moved to private sector and acted as, among others, board member of the İzmir Gaz Distribution Company and as the general manager of Angora Gaz. Gökhan Bey appeared as witness and acted as expert in various arbitration proceedings involving natural gas disputes. He is also in EDAC's arbitrators list. Stephen Finizio is a partner at Wilmer Hale, based in London. He has worked as counsel and arbitrator in commercial and treaty arbitrations and regional courts in matters involving various jurisdictions. Mr. Finizio is a member of the LCIA court. He teaches international arbitration as an adjunct professor at SOAS University of London. He is recognized as a global thought leader in Who's Who Legal Arbitration and is a member of Legal 500's Hall of Fame. William Lowery is a special counsel at Covington. He has a particular experience in the energy and natural gas resources sectors. William has regularly represented and advised clients in price reviews under gas supply agreements and LNG sale and purchase agreements. William has significant experience on sector-specific disputes arising under contracts such as production sharing contracts, joint operating agreements, oil and gas services contracts, gas storage contracts, pipeline transportation agreements, long-term supply agreements for a variety of energy-related commodities. Christian Jeffery'nin is a principal in Charles Service Associates Energy Practice, based in London. Mr. Jeffery provides consultancy services to clients in international energy industry. He specializes in delivering commercial and analytical projects for clients in disputes and arbitration, having worked on such projects throughout Europe, the Middle East, Africa, and Asia. He has extensive experience leading teams gathering and analyzing relevant data and presenting the analytic, commercial, and factual evidence for arbitration proceedings. Mr. Jeffery has been appointed as an expert witness in exit and commercial disputes. Well, we are organizing this panel in a very interesting time. I'd like to share some data provided by the very useful sector periodical, Energy IQ. So the highlights are as follows. Gazprom contracts for procurement of 8 billion cubic meters, BCM, gas per annum will expire by the end of this year. The parties have not yet agreed on a new contract. In the meantime, Turkey's demand for natural gas has been increasing. The demand forecast for the last quarter of 2021 is around 19 BCM. The demand was around 15 BCM in the last quarter of 2020. Further, Turkey's daily peak demand is likely to exceed 300 MCM per day this winter for the first time. There are many reasons for this, yet one of the main reasons is the fact that the dry season resulted in low production in hydropower plants. And this further resulted in reintroduction of natural gas-fired power plants with 4.6 gigawatt capacity with the amendments made to the capacity mechanism legislation in this June. While the daily peak demand is expected to reach around 300 MCM, the average minimum daily entry capacity is around 2,064 MCM with the assumption that supplies under the existing contracts and secured LNG cargoes continue to flow. This expected deficit could have been mitigated by some of the private importers who have been unable to offtake their contractual quantities for some time. One private importer has been unable to import since the beginning of the year due to its dispute with Gazprom. Further, Gazprom ceased supplies to some of private importers as of July 2021, and some of them have not yet restarted the imports from Gazprom. These stem from the failure of these private importers to prevail in the gas price review arbitrations against Gazprom regarding the retroactive removal of the 10.25 discount that it had applied for some years. In fact, most of the private importers have been able to offtake their minimum and annual contractual quantities for some time. This is mainly because they have been unable to achieve a profit margin between Gazprom prices and the subsidized potash prices. The private wholesalers have suffered from the same problem. As a result, most of the private players have defaulted on their take-or-pay obligations. So, to sum it up, we can say that winter is coming. Today, we will cover a range of issues regarding the natural gas disputes. First, Gökhan Bey will provide an overview of the Turkish natural gas market. Then we will discuss the road to liberalization in the EU and Asian markets, as well as the gas price review experiences in these markets. We will then focus on the question as to how Turkey can avoid the contentious and costly disputes that have arisen in the EU and that are starting to seen in Asia. Finally, we will take the questions of the audience. Without any further ado, I will now give the floor to Gökhan Bey for his presentation on the overview of the Turkish natural gas market. Gökhan Bey, the floor is yours.
Thank you, Erdem Bey. Ladies and gentlemen, distinguished participants, first of all, I would like to thank Energy Disputes Arbitration Center EDAC, Mr. Süleyman Boşça, Chairman of National Board, Mr. Erdem Başgül, Partner of Başgül Attorney at Law, and the organizing committee for inviting me to Turkey Arbitration Week for Natural Gas Dispute session. In my speech, I will brief you on Turkish natural gas markets, regulations, and consumption patterns. Turkey met with natural gas in the 70s, but main consumption started after signing of natural gas agreement with Soviet Union in late 1980s. Potash, the state-owned natural gas utility, was the monopoly in all segments of natural gas activities, including the import, distribution, and sales of natural gas until the introduction of the Natural Gas Market Law, number 4646 in 2001. I will refer to this law as NGML during the rest of my speech. The law provided competition in the market activities that are competitive in nature, such as import, wholesale, and distribution. On the other hand, Potash maintained its regulatory and supervisory powers on the market activities that are not suitable for full compensation, such as transmission. Under the NGML, the market activities are import, transmission, storage, wholesale, export, city distribution of natural gas, as well as import, distribution, and transmission of the liquid natural gas, LNG. All entities engaging in these activities must obtain a license from Energy Market Regulatory Authority, EMRA, the independent regulatory authority. It should also be noted that import license holders can also carry out wholesale activities. Production of natural gas is regulated under the petroleum law and petroleum market legislation. However, the producers must obtain wholesale gas license to sell the gas that they produce. 3 years after the passage of the NGML, in 2004, Potash published the network code, which is referred to as sheet in Turkish. Sorry for this, but in Turkish, it is called a sheet. The NGML and network code provided third-party access to the system, namely to the transmission and distribution network, as well as to the storage facilities. The same year, EMRA initiated the first round of tenders for the construction of city distribution networks and for the provision of distribution and retail services to the eligible and non-eligible consumers. As of today, all distribution regions are privatized, other than Istanbul, where the municipality-owned EDAC conducts the distribution activities. With EMRA's board decisions, the eligible consumer limit have been gradually decreased. As of today, the residential consumers with an annual consumption of 75,000 cubic meters and above qualify as eligible consumers, meaning that these consumers are free to choose their suppliers. Without any consumption limit, user unions and cogeneration facilities generating electricity and heat are considered as eligible consumers. On the other hand, the target of the NGML on the liberalization of the import activities have only been partially achieved. The NGML provided that BOTAŞ should decrease its market share to 20% until 2009. However, BOTAŞ is still a vertically integrated entity dominating the import and wholesale activities and is the only actor in transmission and underground gas storage activities. There have been two sets of successful auctions, as a result of which 7 private actors became entitled to import a total of 10 BCM of Russian gas in addition to BOTAŞ. First, in 2005, after the first unsuccessful tender for contract transfer, NGML was amended, and the approval of the supplier was made a precondition for participation in the auction. Russia was the only country which provided such approval. As a result of the auction, these companies were transferred 4 BCM of Russian gas and became entitled to import these quantities through Malkoçlar entry point. By the way, the first import after these transfers could be facilitated by Shell on late 2007. Secondly, by the end of 2011, BOTAŞ did not renew the Western Line contract with Gazprom for the import of 6 BCM per year. As a result of the auction, these companies assumed this quantity. In addition to these developments in the pipeline gas, the NGLM and secondary legislation were amended in 2008 to liberalize the LNG markets. EDAC Gas has been the only importer of LNG, who owns the EDAC Gas LNG terminal. You will now see the next slide, the LNG import terminals. As you can see, there are 2 land type of LNG terminals and 2 FSRUs. The one land type LNG terminal and 1 FSRU belongs to BOTAŞ, and 1 land type LNG terminal and 1 FSRU belongs to private companies. And the 5th one in the Saros Bay is under construction by BOTAŞ as a FSRU. After this overview of the Turkish natural gas market, I would like to explain the consumption and supply trends in the Turkish market. Starting with the consumption, natural gas is mainly used in 3 sectors: households, industry, and power generation. The share of the household segment, here we see, has constantly been increasing. Due to its peak demand in winter and almost only in winter, this increase requires high investment, underground gas storage and importation of LNG in certain months in winter. We'll see in this slide that this is the monthly consumption of the Turkish natural gas. So there is a constant demand around 4 BCM. We can say it is a constant, but in winter times, the demand increases. So in summertime, the demand decreases. So we can say that this quantity might be stored on the underground storages and can be supplied into the system in the winter times, or we have to put spot LNGs during those months. Well, Turkey is dependent on natural gas imports. This is because its domestic production meets only around 2% of its demand. I should note that this situation might change in the future. As we all know, TPAO made a giant discovery. Looking at the current consumption, this discovery is predicted to meet a significant amount of the market demand. The prospect as of today highlights a potential of 540 BCM gas. We learned from the statement made by TPAO after the first phase agreement of the Sakarya field with the Subsea 7 and Schlumberger consortium that a production of 10 million cubic meters per day is planned in 2023. As you will able to see from the next slide, 2021 is a significant year for Turkey since at the end of this year, the long-term contracts amounting to 15.9 BCM of annual quantities from Russia, Azerbaijan, and Nigeria contracts will have to be expired. 6.6 BCM Azeri contract and 1.3 BCM Nigerian contract have already been expired. 8 BCM, 4 BCM Potash, and 4 BCM private importers of Russian contracts will expire by the end of this year. Further, the 16 BCM Russian Blue Stream and 10 BCM Iranian contracts will expire in 2025 and 2026. In response to these expirations, Potash has recently signed some new contracts. First, it signed a new sales and purchase agreement with Azerbaijan for Shah Deniz 2 field in connection with realization of TANAP project. Recently, Potash signed another contract with Shah Deniz consortium until the end of 2024. However, this contract does not fully replace the expired 6.6 BCM contract. Based on the capacity reservation, we can see that Turkey will be able to offtake between 2.6 to 3.8 BCM per year under these contracts. That's why I didn't put the short-term contracts into the long-term contracts slide. Potash has also signed 3-year spot agreement with Qatar in 2017 and extended the existing Algerian LNG agreement. In fact, Turkey has been preparing itself for these expirations for some years. As you can see in the next slide, Turkey increased the share of the renewable energy in its energy mix and thereby achieved a substantial decrease in electricity generation through the natural gas-fired plants. We'll see the capacities of this geothermal, wind, and solar powers, and this is the hydropower, and this is the thermal powers, includes the natural gas power plants and coal power plant is almost flat, but especially in the geothermal, wind, and solar capacities are increasing. Further to diversify its suppliers, Turkey increased the LNG share LNG gasification capacities of its 2 land-type LNG terminals and commissioned 2 FSRUs. In this slide, you'll see that the pipe gas is, the share of pipe gas is decreasing and LNG share is increasing, except this year for the first 8 months. This green line is the US LNG share in total LNG. So this is the LNG, for example. This is the 10%. If we say 10% LNG, 27% of this 10% is the US LNG share. This helped Turkey to particularly benefit from the US LNG imports at the times when LNG were competitive. As we all know, this is no longer the case. LNG prices have skyrocketed. And despite the increasing oil prices, oil index pricing formula now reveals a significant lower contract price when compared with the current LNG prices. I would finally like to touch upon the pricing issues in the Turkish market. Under the NGML, the wholesalers may freely agree on the natural gas price between themselves. The only legal limitation to pricing is that the local distribution companies must purchase the gas with the most convenient price, which is the BOTAŞ price applicable to distribution companies. However, in practice, BOTAŞ tariffs serve as a benchmark due to its dominant position. And BOTAŞ, as a state-owned entity, has followed the government policies and refrained from reflecting the cost of the US dollars-based import price in its TL-based tariffs. On the other hand, to compete in the market, private wholesale companies must either be able to purchase gas from importers at competitive prices or BOTAŞ must abolish the subsidy. However, the wholesale and import companies have, from time to time, been unable to achieve a profit margin between BOTAŞ tariff and import prices. And these naturally create disputes between the wholesalers and their suppliers, particularly when they become unable to offtake their contractual quantities and fulfill their take-or-pay obligations. On a closing remark, as approximately 40-45 BCM of long-term contract gas will expire in the next 5 to 6 years period, Turkey should re-evaluate the import strategy and prepare itself possible negotiations with a view to reduce the gas import bill. It was told that Turkey's general policy for all new purchase must be with price based on the world and European gas market hub pricing principles with flexible terms. Flexible duration, flexible take-or-pay, flexible destination clause, flexible currency. In my opinion, such success in this policy will depend on our relations with our neighbors, changes in world gas prices, and how quick the green policies develop and how willing we are to liberalize our market. Thank you for your attention for this part.
Thanks a lot, Gökhan Bey. Thanks a lot for putting all the major issues in a nutshell. Before moving on, I'd like to pose a question to Christian. Christian, Gökhan Bey mentioned that Turkey was able to benefit from US LNG imports at the times when those prices were competitive. Does such lower LNG prices affect the perspectives of the buyers under their long-term contracts?
Yeah, thank you, Erdem, and thank you, Gökhan, for that detailed look at the Turkish market. So, as Gökhan said, we've seen some of the ways that Turkey is exposed to international pricing, particularly through LNG imports. And following on from that, I think the best way to answer this question is probably first to sort of step back and take a look at a bit more theoretically how importers in Turkey or other gas markets might look at alternative international pricing, and then to look at some recent price trends in Europe and what those can tell us that might be helpful from a market perspective in this discussion, focusing on contractual price disputes. So I think importers really have sort of two ways of looking at their pricing. So the first is a price formation approach. So you can imagine that I'm a gas importer, and I'm paying a price that's set differently from how my onward sales price is set to my end users or the distributors that I'm selling my gas to. It might be higher or lower. In a dispute context, it will generally be higher, but importantly, it's going to change in a way that's fundamentally different. So without stepping on the toes of what the others on this panel are going to say later on, that's how a number of European importers, for example, viewed the situation that they found themselves in a decade ago. So some of the early issues that were seen in Italy, Germany, importers got into some significant take-or-pay issues for exactly the same reasons as in Turkey. They were facing competition from buyers that were able to sell gas cores on the basis of traded gas prices rather than oil index pricing, and that caused them significant take-or-pay issues. The other way of looking at gas import pricing is going to be a price level approach. So rather than looking at price formation, I just want to pay a price as low as possible for my gas imports. So another historical example, that was how a lot of Asian importers were viewing their pricing for a certain amount of time. They were able to pass their gas import, or in that case LNG import costs, on to end users, and price formation was of less importance to those importers. What became important was pressure from governments or regulators to try and give end users lower prices. So as I'm sure Steve will be talking about, that and led to an interest in Henry Hub as a possible alternative. There may have been a shift in how that's looked at now, and I'm sure that's something we can discuss later on. So how can we apply that to the sort of situation that buyers in Turkey or similar international markets face? So let me try and share my screen. So hopefully you can now see a chart of European gas price benchmarks. So what I'm showing on this chart is the green line is the TTF month head price. So I'm sure a price series given recent news that we're all very familiar with. And then comparing that to the dark blue line is an oil index sort of benchmark. So ignoring the price level, this is intended to show us how an oil index price would have changed over a similar sort of time frame. And then the light blue line is the German border price, which is a pretty widely used benchmark for European imports. So what do we see? Well, the first obvious trend is this downward trend through early 2020 and into mid 2020, where we reached almost record low TTF prices. What caused that? We all know, unfortunately, 2020 was the year of COVID. Collapse in demand caused a collapse in the European spot price, and that affected the whole of Europe, and that is what led to these cheap LNG imports being available to Turkey. And as we just heard from both Erdem and Gökhan, this led to significant pressure on private importers. At the same time, this is exactly where a price level approach to looking at international prices can be really attractive. I can see cheap gas available elsewhere, and I'd like to achieve similar price levels. And it's something we've seen in the market. There are market participants who haven't been able to or haven't wanted to switch to hub indexation, and suddenly they're able to look at a wider range of markets in exactly this light. I think an interesting example here is in Eastern Europe. Some of the markets have changed significantly over the course of the time frame I'm showing here because of the Gazprom commitments to the European Competition Commission. So in some of the Baltic states, but more importantly, neighbouring Turkey and Bulgaria, mechanisms should now exist for gas import prices to reflect the price level in competitive European gas markets. And by that, we can mean exactly this TTF price series that we're seeing leading to lower import prices in Europe. So if I'm looking at a new contract extension, I'm in a dispute, I can look at these countries, which historically have paid relatively high prices, and assume rightly or wrongly that these countries are now paying much lower prices for their imports compared to what I'm paying. And in Turkey, this might also mean looking at gas transiting the country to other markets. We heard earlier about new Azeri contracts, and those are going to be potentially priced very differently to similar gas for Turkish imports. But what happened after this price low? We all know that we're currently in a record high TTF or European gas price environment, and it's reflected throughout Europe. So what caused that? Well, it was a rebound, particularly of Asian economies from COVID. That's pulled LNG away from Europe. Got low European gas storage levels after a cold winter 2020, 2021. And there's been some supply issues as well, both in terms of European production, but also in some European import infrastructure. Now I'm in the UK, oldest, most liquid traded gas market in Europe, well-established price formation mechanisms, but we've been particularly hard hit by this current pricing crisis. In September alone, 9 of our energy suppliers ceased trading and had to be acquired by larger, more established companies. But in wider Europe, at the import level, we've certainly seen a number of quite large importers who are buying the gas at traded gas market prices, some having entered those agreements relatively recently, seeing low European prices, and they're getting into trouble. If you've got significant competition, got more nimble competitors, other fuels, you're poorly hedged, you're either facing large losses, or similarly to private importers in Turkey, you're incurring large take-or-pay issues. So just to wrap up, I think that the lesson of these sort of international prices is that there isn't necessarily a right or wrong way to think about these particular issues. What's important is to remember that there isn't a one-size-fits-all, and that some long-term solutions can cause you some short-term pain sometimes, and short-term solutions can cause you some long-term pain. So in a dispute context, we're going to want to consider the dynamics underlying these international markets, but also how our current import pricing relates to those prices. So with that, back to you, Erdem.
Thanks a lot, Christian. It was extremely useful. Now we will talk about the price review arbitrations in the EU. But before doing so, I'd like to pose a question to Steven. Steve, could you please explain us the general framework, the typical flow of a gas price review? Gas price review.
Yeah, I will set the scene. We're talking already between Dr. Yardım and Christian about the various drivers that lead to disputes. Let's take a few minutes to talk about the contractual mechanisms that are used to pursue these price reviews and price review disputes. So I'm going to pull up some slides here. Give me a sec. So I'm not sure if you can see the slides. Can people see the slides?
Yep, we can.
Okay. So most long-term gas supply contracts have some sort of contractual review clause that allows the parties to periodically review the price formula. And you've heard already that the price formulas can be fairly complex, and Christian just explained the different drivers and some of the different ways you can set a price formula in a contract. The idea is that a price review clause, given the complicated nature of those formulas, will deal with the situation where that formula is no longer expecting as the party is expected to do so over time. Saying that, obviously, given the volumes in these long-term supply contracts, changing the price formula can have very significant financial consequences. And the idea behind the price review clause in a long-term contract, because you wouldn't ordinarily be able to review a price in a shorter term contract, but because these contracts can be 10, 20, 30, 40 years, the idea is, on the one hand, you need to balance the need for some certainty and predictability about pricing. On the other hand, you have to recognize that there may be circumstances that change over the 10, 20, 30, 40 year lifetime of a contract that does require you to change the price formula to restore what the party's original intent was, or what the bargain was in the contract. So that's the motivation for a price review clause. And there are lots of issues that can lead to pricing disputes. I'm not going to go through all these, but as you can imagine from what Dr. Yardım and Christian already started talking about, there are lots of things that can lead the parties to having a dispute about whether the current formula in their long-term contract actually meets their expectations. So how do we do that? Well, we have price review clauses in contracts with very widely varying terms, often similar sounding, but when you press on them, different terms. Most price review clauses have provisions that deal with the frequency of price reviews, the procedures to be used in price reviews, the standards or requirements to bring a price review, and then to adjust the price, and some form of dispute resolution. And I'm going to take a minute or two to walk through those provisions. So when we talk about frequency, most price review clauses will say when and how frequently a price review request can be brought. And so in European contracts, that usually is, and again, these are just generalizations. Usually the clause will say that a price review can be brought every 3 years or 2 years or 4 years, and it may cap over the lifetime of the contract how many reviews can be brought, but there also might or infrequently see something called jokers or wildcards. It will say a party can bring a price review request every 3 years, plus over the life of the contract has 1 or 2 out of sequence opportunities to raise a price issue. In Asia, historically there weren't price review clauses in many contracts at all. And where there are, historically, we've seen fewer opportunities in the contract to bring a price review, and often spaced over longer period of times, 4, 5, 10 years between price reviews. So that's one common feature of price review clauses. Another is procedures in order to initiate a price review. And often what we see is some form of formal notice requirement. So a party who seeks a price review has to submit some form of written price review request, and some contracts will specify that it needs a certain level of substantiation. And what we also often see are requirements that the parties then meet or negotiate for a minimum period of time once one party initiates a price review. So it often will say the parties are required to meet and have good faith discussions for at least 6 months, for example. So we see those as common provisions in many price review clauses. We also have in clauses standards or requirements that have to be established to obtain a revision, and also may cabin what sort of revision can be provided. And this gets more complicated, and I don't want to get too hung up on it, but there's often some sort of trigger requirement that's shorthand used by people who do this, that will often require a party to establish if there's been some sort of change in circumstance or some sort of market development that's not reflected any longer in the contract price formula, or otherwise to show that there's a justification to trigger a price review. If that trigger is met, the contract may then refer to how you implement a revision. And it might say that it has to be fair or equitable, reasonable, or it might say it has to restore the original bargain, but there may be language in the contract that says what adjustment follows from the trigger. And many contracts will refer to benchmarks and other requirements. So it may require that certain benchmarks, such as import prices into this market or to other markets, or the ability of the buyer to economically market the gas in any case, be taken into account when setting the adjustment, or sometimes when also considering whether a review has been triggered. I put an example on the screen, but we're not going to go through that. Then we have dispute resolution mechanisms, and often the price review clause will have its own dispute resolution mechanisms, but sometimes there'll be a more general one that applies to any contract terms. And in European contracts, that's almost always a right to commence a commercial arbitration. In Asian contracts, we increasingly see that, but historically many contracts were silent as to what a party could do if they didn't reach agreement on a price review, or simply required the parties to meet and discuss. And I think later on, when William is covering some of the future, we can talk about the relationship between that arbitration or other dispute resolution procedure related to price reviews and others that might be in the contract, expert determination clauses, the general arbitration clauses, but there's sometimes confusions around that. And frankly, in Asia, sometimes price reviews are subjected to expert determination and not to arbitration. Now, in terms of what happens, let me quickly tell you what happens when we do have a price review. So we have that formal price review request. And while we're doing that, so one party has notified the other that they want a revision of the price. Maybe they've substantiated that. At the same, they then have to have formal meetings or negotiations for 6 months, often extended for longer periods of time. Around that, they may also be having commercial discussions, not just about the pricing issues, but as Dr. Yardım said, there's also lots of other terms in these contracts, and the parties may be discussing how does the pricing fit with other terms like flexibility of supply, optionality, various other issues. If they can't reach agreement through those formal or informal meetings, then we have an arbitration. And again, while that arbitration is going on, we may have commercial discussions. Now, some of the specifics of price review arbitration is that it may be restricted to just the pricing issue. So the tribunal may only have jurisdiction to revise the price and may not be able to touch the other important supply terms in the contract. Price review arbitrations are usually heavily dependent on expert testimony, people like Christian. We sometimes and increasingly are seeing counterclaims, which if you think about it can be a little bit strange because one party is saying there's been a change of circumstance in the market, so I need a lower price, where the other party comes in and says, no, there's been a change of circumstance and I need a higher price. We often see bifurcation in arbitration procedures where the trigger, is there a justification for a price review, is decided in one phase. If the tribunal decides yes, then we have a phase in which the tribunal is meant to address what the adjusted price should be. We sometimes see competition law issues, as you can imagine from some of the things that Dr. Yardim said. You can imagine how competition law issues can come into price review contracts. We often this is very time consuming and expensive, and it's going on at the same time as we're continuing to have a supply relationship. And we may, as this takes 1, 2, 3 years, we may be running into second price reviews under those scheduled price reviews, and complexities around how one existing price review overlaps with other existing price reviews or future price reviews. And I think William will pick some of that up later. And then finally, we get to a settlement or an award. And I say settlement because historically, many price review arbitrations settle before we get to a final award. The terms of either a settlement or the awards, for better or worse, tend to be confidential. So we know what sort of issues parties raise, but we don't always know how they're resolved. There is often voluntary compliance with price review awards when an award is made, because these are ongoing contractual relationships, usually highly valuable. But that may require some further negotiations, including around non-pricing supply terms, to come to some sort of larger readjustment to the contract. And again, timing issues at the award or settlement stage because of the overlap with the next scheduled price review or previous price reviews in that ongoing relationship. So that hopefully gives you a sense of what we're talking about when we talk about contractual price reviews.
Thank you, Steve. It certainly does. William, could you please give us a bit of background in terms of the liberalization process in the EU market? I think, the liberalization was, somehow triggered by the disputes related to pricing, wasn't it?
Well, I think that's right. Thanks for the question, Erdem. I think that liberalization in Europe and a series of EU directives, in part, triggered a number of price reviews, and those price reviews, in fact, progressed liberalization in some ways by addressing price formation mechanisms. But I should note that we're working here from the adage that those who don't know their history may be at risk of repeating it. So it's worth exploring this a bit. And second, I should note that my summary here is going to be general and high level. I think we could probably spend all day examining the history of European gas pricing. I'm not so sure anyone would enjoy that presentation. But needless to say, there's a lot of perspectives and views on what I'm about to say, depending upon where you sit from the perspective of supplier or buyer. So if I say anything especially controversial, it's because I was representing some other client, I'm sure. To set the scene, I think at an interesting point of time, we could go back all the way to 1959 and the Groningen field and talk about the origins of the EU gas market. But I think the most interesting point in time to sort of look at the start of this story is at the fall of the Soviet Union and the European continental gas market as it existed in the early 1990s. And what you have there was really a series of long-term contracts, primarily between state-owned suppliers and monopoly transmitters and distributors within various geographic markets, usually along national boundaries. So, the main source of supply was pipeline gas. LNG was at a nascent stage at that point in time. The source of the gas were a few fields within the EU, such as Groningen, which I just mentioned. But then a primary source of gas was from the Soviet bloc or Gazprom in Russia. And then you had sources of supply from the North Sea and North Africa and some other locations. The hallmark of these contracts is that there were very stringent take-or-pay terms with very limited flexibility, and that there was a limitation on resale. So the gas was destined for a particular market. There were destination clauses. In addition, the pricing mechanisms at that time reflected the fact that there was no real transparent market for gas at the time. Gas was a substitute energy source. And so the price formula in these contracts, the price formula that Stephen just mentioned, which were agreed to sort of provide some level of certainty, but also adapt to market changes, were often based upon alternative energy sources, most frequently oil and oil products, but also coal, and sometimes, and I recall one Czech contract that was priced with respect to wood, which was the alternative heating source, which was quite amazing. The long-term contracts in many cases were agreed because of the need for upstream investment. So the suppliers needed investment they needed a stable source of financing to continue to invest in supply. But also from the buyer's perspective, from the monopoly buyer's perspective, they were essentially creating a market. So they needed to have a long-term stable source of supply to justify that investment. As Stephen mentioned, there are price review clauses in many of these agreements, if not most of them. And these agreements, I think the only thing that can be broadly said about a price review agreement is that while they're all similar in some ways, they're all different, and there's no typical or standard price review provision. Timing varies. What do you need to do to revise the prices? But fundamentally, they're designed to deal with changes in circumstances, and it's from this platform that these price review provisions really went to work when the EU started making a number of decisions about gas policy. And in particular, this may be old hat to many people on the call. And again, this is a very high level summary of these directives. But there were 3 directives. There was the first EU directive in 1998. So that EU directive created some very initial and tentative steps toward the adoption of a harmonized set of rules for EU's gas transportation infrastructure. Essentially, it permitted but did not require states to unbundle their transmission and distribution activities. Nor did that directive didn't really address interconnections between the EU member states. So essentially, the directive said, member states, you need to pass laws in accordance with these principles, but there weren't very many strict principles for liberalization at that time. There was a second EU directive in 2003, which really upped the ante a bit. And that directive was aimed at harmonizing the rules across various EU member states and facilitating interconnections between the separate gas markets that existed in those states. In addition, that EU gas directive required member states to allow third-party access to transmission and distribution systems, as well as to LNG facilities, which were becoming more important to the EU gas market at the time. And as a result, this allowed for new suppliers and true gas trading to occur. I think for the first time in Europe, you had gas-to-gas competition really emerging. And then all of this was furthered, I think, quite dramatically by a third directive, which was part of the third EU energy package in 2009. And that energy package was reflected the EU's policy of really breaking up vertically integrated energy utilities throughout continental Europe. And I think it's with that directive that you saw the real emergence of a robust gas-to-gas competition within the continent. You saw a lot of gas flowing from different member states to different member states. The interconnections were much strengthened. And in reality, you could really talk about an EU gas market at that time for the first time. Others may disagree with that assessment. I think that's my view. So as Erdem's question indicated, liberalization was really advanced here through a series of disputes related to pricing. So each of these EU directives, initially by a few meters, and then later by whole kilometers, changed the ballgame in terms of what market conditions were. And the price review provisions in these agreements were often triggered by parties because of the changing conditions. It became very, very common for parties to point to liberalization, as well as other energy markets. For example, step changes in oil prices or the growth of gas-dependent industries, because there was now a real gas market, and these industries were creating new competition for new alternative energy sources. So there were these changing market conditions. Parties would point to them and say, this is the reason we need a new price. And they would refer to the terms of the contract. They would argue that before tribunals, an award or settlement would be published. And then that would become the touchstone for the next series of arbitrations. You would point to and say, hey, that just happened in that arbitration. And you would point to the new market prices that existed. And as you can see, the ball started to roll. It wasn't uncommon at the time, and it still isn't uncommon for former monopolies, former state-owned monopolies, the companies that had previously been vertically integrated, to point to prices that were obtained now by new competitors, and say, I should be able to obtain that same price under my contract, and in one way or another use that as evidence in an arbitration. I think Christian earlier referred to the German border price as a great example of that. Also, the hub prices that were starting to emerge throughout Europe, those became important price indicators that parties would point to in these disputes. No longer was your dispute solely about the price of Brent or high sulfur fuel oil. It was about what is the price of gas in a particular market. And so I think because of these market tensions, you had essentially competing price formation mechanisms, you had changing market prices. There was a whole series, and there continues to be a long-running series of price review arbitrations throughout Europe. Coupled with this, Stephen made the point that sometimes the jurisdiction of the arbitral tribunal is limited to just considering changes in the price formula, but obviously some of these issues are not just related to pricing, they're related to market access, your ability to resell gas within a market where you were once a monopoly and are now competing with new market entrants. So as a result, the scope of these price review arbitrations started to creep, I would say, and it started to subsume into all sorts of issues under these contracts. And where the tribunal may not have jurisdiction over some of those issues, parties began to refer to the European Commission and EU competition law to support their claims. So that's a further dynamic. I would say that's a relatively speaking, going back to the 1990s, more recent dynamic in price reviews is to refer to these European Commission decisions, to label certain provisions within contracts as either invalid or unenforceable, and therefore demand that the pricing provisions be reconsidered in light of them. A great example of that is there's European commissions that take a very dim view, shall we say, of market restraints in interconnected markets, particularly resale provisions, which there's a good argument that European Commission law deems per se invalid until shown otherwise. So in these disputes coupled together, these pricing disputes, these price review arbitrations, these competition law disputes have snowballed into a situation where it's very common to see price review arbitrations triggered whenever it comes up for renewal as parties jockey, so to speak, for the best available price under their long-term agreements. And it's something to be learned from, I think, because in reality, arbitration is a very costly and expensive way to go. And I say that as primarily an arbitration lawyer. So it's an admission against interest, so to speak, to say that. But I think more and more we see clients thinking, is this really the way we want to manage our long-term relationship with a supplier? Is this the way we want to go? Is there a better way? And perhaps we can talk about that later on in this discussion.
Thanks, William. Christian, by the way, do you have any comments on William's remarks?
I think the main comment that I would have, if I think back sort of 10 years ago, William spoke about history not repeating itself or repeating itself as the case may be. And one way I think history won't repeat itself is in the competition side of things that William started touching on at the end there. 10 years ago, and I say this as one of the non-lawyers on the screen at the moment, the competition arguments were interesting to the lawyers. The clients didn't necessarily understand them so much, and certainly sort of the market experts didn't necessarily understand them, and the tribunals didn't, in my experience, and Stephen or William will have more experience of this, tribunals didn't really want to touch them. But following sort of 2018, we've got the commitments from Gazprom that the EC has accepted. We're certainly seeing more clients taking an interest in competition style arguments, and I suspect that tribunals will start paying a lot more attention to those. So I think it's a really interesting time at the moment, particularly in sort of Eastern Europe.
Thanks a lot. Steve, now I think we can move on to the Asian markets. Nowadays, we see an unusually increasing number of price review cases in the market, aren't we?
Yep, absolutely. It's a noticeable and growing trend. Let me set the scene a little bit about Asia. And why are we talking about Asia and Europe at an event focused on Turkey? I think in part because Turkey sits between the two, not just literally, but because while Turkey is closely tied to European markets, it sits outside of some of the issues and the EU regulations that we've talked about. So in some ways, it's in a point in its development as a market similar to where some of the Asia Pacific countries are. So let me talk a little bit about Asia Pacific and this sudden growth in arbitrations there. The Asian energy markets differ significantly between themselves. So where in Europe you see a real similarity now in Western European markets, partly because of the EU regulations that William described. But in Asia, LNG has become a significant factor in the energy mix. Asia is the largest import market, or has, I should say, markets, because again, they're each different for LNG. So 2/3 of all global LNG imports go to Japan, China, South Korea, India, Taiwan. And so it is a critical market. And some of the supply and demand dynamics that we've already been talking about are driven by that pull of demand over time into Asia. And some of the disputes that William talked about in Europe in part had to do with the shift of LNG that originally was going to be in the US, then to Europe, and then getting pulled to Asia, particularly after the Fukushima disaster, but in part because of this pull of LNG and the growth of LNG in Asia. But the supply and demand balance is dynamic, and we see shifts not just from things like the decisions about nuclear, but now we're going to see more shifts as we talk about the use of renewables and alternative energy, and as various countries change their policies on energy mix. So we're going to continue to see this, plus the shorter term effects of things like the pandemic, winter, literally, those sorts of things all have effects on the supply demand balance, and we see that in Asia in particular. There is, maybe I've already said this in a way, but there is no global market for LNG. There's no single Asian market for LNG. There's no LNG market price in Asia. And we're not talking about North America in part because there is a market price. And part of the story that William told you about Europe was the development of a market price, which has led to a lot of the disputes. But we don't have a global price at this stage. Christian can tell you whether or not he thinks we'll ever have a global price. But there is certainly not a global price in Asia, and there's not a single market. So you can't, like you can in Northwest Europe or Europe now, say there's generally market prices that are very close. You can't say that about Asia. Each country has its own LNG market with significant differences in the regulatory frameworks, differences in who buys and sells gas within the market, the role of any pipeline gas. Some countries have pipeline access, others don't, and competition with other energy sources. Plus, gas markets are changing pretty rapidly in the region because state-owned or incumbent gas companies and electrical utilities that typically have been the customers for LNG still are the major customers, but there are liberalization efforts at various stages of progress in those markets, and that means new entrants are coming into the market, but that's still a work in progress. Historically, we've seen gas supplied to Asian markets through long-term sales contracts, but this is changing also, as Dr. Yardım was talking about with Turkey. We're starting to see increases in short-term and spot trades. That's driven by a number of factors, including the deregulation and liberalization of domestic markets. Sometimes it's because of oversupply. We've had, at the moment, Christian showed you that slide, which showed you that we're now in an undersupply moment, but it was an oversupply issue a few months ago or last year. When there is oversupply, that can sometimes drive shorter term or spot trades. We also, as in Turkey, we're seeing the expiration of long-term contracts in Asia, which gives some buyers some flexibility to enter into shorter or more flexible contracts or to go into the spot markets. And so we're seeing a moment in time where some of the things that were talked about in Turkey are also happening in Asia. And we're also seeing in Asia new long-term supply contracts, again, as we see in Turkey and are about to see in Turkey. Because of the nature of the markets, we still see oil index price formulas in Asia, more so than we see in Turkey, and certainly much more than we see in Europe at this point. Coming on to why we're seeing disputes, I said earlier, we often didn't see price review clauses in older Asian contracts, but we're now starting to see ones. We're often seeing ones that look a lot like European ones, but they don't all look like that, which can complicate whether or not we actually see disputes. But there's no doubt that we're seeing many more price review requests. I'm distinguishing those from arbitrations, and we're starting to see arbitrations. And let me give you a quick history of arbitrations in Asian markets. There was a mini wave of price review requests about 10 years ago when sellers wanted higher prices. There then was a second wave, again, of requests for review, not arbitrations really, but requests for review in 2015 after Petronet in India got what was publicly reported as a significant price reduction from RasGas, and that led to other companies starting formal price reviews to try to get similar reductions. And then what we started to see now is what you might call a third wave, which is started publicly in 2018 or so when KOGAS started an arbitration. There also was an Osaka gas arbitration. Those are sort of publicly referred to, but at least 15 contracts are in formal price reviews in Asia. And I would say anecdotally, it's much higher than that. And anecdotally, a number of those are in formal arbitrations. And there's just no doubt we're going to see more of that. And why are we going to see more of that? And it's some of the stuff that drives disputes that might arise in Turkey. It is the liberalization and increasing price sensitivity that goes hand in hand. So as you start to liberalize those markets, that means buyers are seeing a loss of customers to new market entrants, and it's harder and harder for buyers to pass prices downstream to customers, right? So suddenly they care about pricing. When you have an increase in global supply, and again, this is shifting around, but when there was more of a glut, buyers are less concerned about the idea that they need these long-term contracts or they need to concede on price to get security of supply because they have other potential sources of gas or LNG. So that puts a lot of pressure on the incumbents to reduce prices and reduce costs, and so price reviews become more attractive. Although we still don't see that same intensity of competition as we saw in Europe, and we don't have that central motivating factor like the European regulations that William described. But we do, and we're at various places, as in Turkey, various places in the liberalization process. But that is one of the big drivers that leads to price sensitivity by buyers. We also see this growth of supply and availability of lower spot LNG prices, again, particularly when we have oversupply. And so spot LNG prices have driven a much bigger part of the volume. Spot LNG has driven a much bigger part of the volume of the market. And that pushes buyers, again, to be more aggressive in price reviews when they're seeing a real difference between spot prices and their contract prices priced to oil. We also have this general fluctuation in oil prices. So we've had historically low oil prices since 2014 until now. And now suddenly we're seeing a switch, which will change the dynamic again. And as part of that also, and I guess last points, we have in Europe the development of hubs, of gas hubs, and both Christian and William referred to those, but we haven't seen, and the question is whether we will ever see that in Asia, or certainly anytime soon, which then has consequences for this decision about whether you're continuing to use oil indexed pricing, and then the effect of the fluctuations in oil prices. And so then we're in a world where the broader supply demand developments that we're seeing everywhere are going to have an effect in the short term, driving to new disputes, the pandemic, as we've already talked about, ongoing decisions about the energy mix, including in some cases consideration of restarting nuclear and others moving away from nuclear. So those sorts of policy decisions. And then I guess I would finally say, people often say it's cultural. And I think there are two interesting aspects. The idea is cultural in the sense that one of the reasons you didn't see price review provisions or you didn't have price review provisions that let you go to arbitration in older contracts is this idea that in some Asian cultures, they're loath to have formal disputes. Whether that's true or not, what we're seeing is an increase in the players involved in the Asian markets who do resort to arbitration, certainly elsewhere in the world. And as William said, it has become institutionalized for many energy companies in Europe, that you automatically are going to go to arbitration, at least to get the process started, and you're not going to resolve your price difference until you have a formal arbitration. That sort of institutionalization of arbitration is going to affect the behavior of Asian parties. And there's also just a growing realization, well, two things: growing realization of the importance of price because of that inability as things liberalize to push prices down. So companies more and more care in a way they didn't before. So it matters, and it matters in more fraught economic times. But also a growing realization that a price review and even arbitrations can be reconciled with continuing to have a working commercial relationship with your counterparty. And therefore, it isn't the end of the world if you actually formally request a price review or initiate a price review arbitration. So I think that's why we are in a place where there is absolutely no doubt that as of a couple months ago, I would say we've gone from 0 or 2 in 2018 to at least 10 arbitrations going on right now. What will happen in the next months with some of those, the changes in supply and demand and price that Christian's slide sort of illustrated and Dr. Yardim has explained, may make some of those go away, but it also may lead to others and may exacerbate some of the existing disputes depending on the terms of the contract. So that's where we are in Asia.
Thanks, Steve. Any comments, Christian?
Well, when I think about what Stephen said from an expert witness sort of perspective, I think probably the main comment with respect to Asia actually goes back to some of the slides Stephen showed earlier, where he commented that a lot of the time, if there's a price review clause, it will focus on comparison to benchmarks, and that is something that we also see in Eastern European contracts, Middle Eastern contracts. And if that is the focus of a price review, then from an expert perspective, the issues come a lot more to things like what data is best to use, how best do I apply that data in a price review context. And it will be interesting to see in Asia, also in Eastern Europe and the Middle East, how developing markets contribute to experts having more of a focus on market dynamics and less of a focus on much more data-driven questions.
Thanks a lot, everyone. By the way, I'm not avoiding eye contact. On the contrary, I'm trying to maintain an eye contact with you. The screen is here, the camera is, and audience are here. So just to avoid any misunderstanding. In the last part of our panel, we will discuss the possible solutions for the Turkish market in terms of avoiding disputes. We will brainstorm about this topic, but before we do so, I'd like to ask Gökhan Bey, could you please provide us with a bit of background of gas price review arbitrations of Turkey?
Thank you, Erdem Bey. According to my knowledge, the first natural gas sales and purchase arbitration of Turkey was between BOTAŞ and with Iran's NIGC. First application was made in 2004. The tribunal ordered that the NIGC shall reduce the price by 16.5% and make a retroactive payment in the amount of $971 million to BOTAŞ. After the first arbitration, Iranian gas still quite expensive compared to the gas purchased from Russia and Azerbaijan. Thus, in 2012, Turkey brought Iran to arbitration for overpricing on gas purchase during the 4-year period from 2011 to 2015. Turkey asked for reduction of price and compensation of BOTAŞ losses due to its high pricing. Turkey also claimed compensation of its damages due to NIGC's failure to make ready and deliver the daily contract quantities under the contract. The tribunal dismissed this second claim. However, the tribunal ordered both parties to agree on the reduction between 10% and 15%, according to Iran's Fars news agency. Iran paid full compensation of $1.9 billion to Turkey by supplying 8 BCM of gas for free. There are 2 arbitral awards under the agreement between BOTAŞ and Greek DEPA for the export of 750 million cubic meters per annum from Turkey to Greece. First one is initiated by BOTAŞ for the price revision in 2011 and finalized in 2015 in favor of BOTAŞ. According to Thomson Reuters arbitration blog, BOTAŞ argued that the price should be adjusted based on Brent, a reference to the price of crude oil. DEPA resisted this, arguing that the formula should be based on a price index known as BAFA, an average price of all gas imports to Germany set by the German Federal Office of Economics and Export Control. DEPA paid approximately $181 million to BOTAŞ. DEPA then made its own request for a price review in 2015 and subsequently brought a claim under the same price revision clause. It argued again for a change on the basis of the pricing formula. The tribunal ruled in favor of DEPA this time, reportedly requiring BOTAŞ to return overpayments approximately more than $300 million to DEPA dating back to 2011. Another case was with Russian Gazprom export. Gazprom export gas sold to private importers with a 10.25 discount from 2015 to 2016. ex-energy minister Taner Yıldız said that this discount was provided for BOTAŞ as well. On the ground that this discount did not materialize, BOTAŞ decided to take Gazprom export to arbitration. President Erdogan said that the parties decided to settle the dispute based on Gazprom's payment of $1 billion to BOTAŞ. Private sector companies, on the other hand, demanded the continuation of this 10.25% discount after 2017. When Gazprom Export did not accept this, some of the private importers initiated arbitration. Gazprom Export won all these arbitrations. There is no arbitration process on the public knowledge between wholesale companies, so I can't make any comment for such an arbitration, if any.
Thank you. Thanks a lot. I have just a note to the audience. You can send us your questions via Zoom. We will have around 10 minutes to answer your questions. So I think we are now, we can now proceed with the most interesting question. And I'd like to pose that question to William. William, as Turkey, do you have any suggestions as to how we can avoid costly and contentious disputes here?
Well, Erdem, I'm always happy to answer the most interesting question. Hopefully I provide an adequate answer. I think, Stephen had a very good word for it earlier, that these disputes are becoming institutionalized in markets. They were institutionalized, they certainly are institutionalized in Europe. They're becoming that way in Asia. And I think the participants in the Turkish market really want to sort of figure out whether they want these types of disputes to be institutionalized in Turkey as well. There's some history of price review disputes, but the sense is that Turkey's the market on the verge right now. And I think that's particularly the case because if you look at the helpful slide that Gökhan put up earlier, listing the expiry of certain contracts and the entry of new contracts, right? It's an opportunity for parties to think about how they tailor their price review provisions to reach agreement and minimize costs. Because I think in a commercial way, that's the ideal solution for everyone, right? I mean, much as this is Turkey Arbitration Week, right? We're in the business of resolving disputes, not creating them. And so to the extent that disputes can be avoided by clever drafting, I think that's worth parties considering. One example that Stephen gave earlier was expert determination. And I think I agree with him that that is something that's seen certainly more frequently in the Asian market. I've also had some experience of expert determinations relating to supplies into India. And I think that can be an effective way of at least commencing a price review dispute. So you can make expert determination binding or non-binding. A non-binding of expert determination is really a sophisticated mediation, is perhaps a way to think about it. And that might be worth parties exploring as they think about their clauses, because what that really does is it forces parties to think about where the market's at. It requires them to front load their thinking on the data and some of the crucial issues that are really at the core of any of these disputes. And as Christian alluded to earlier, sometimes this is a principled issue about price formation, or sometimes it's just a pragmatic issue about how can I get the best price for now. And it's important for parties to sort of suss out where they stand on those issues at the outset of a case. And so expert determination is one viable means. Another thing that parties might want to do if they're thinking about drafting a price review provision is to set some sort of deadline or time frame for the arbitration. Now, those timeframes are not always binding. There's various rules on that in various jurisdictions about how enforceable those are. But the problem that Stephen alluded to earlier, where you have consecutive price review arbitrations under the same contract, overlapping data sets, and contrary claims, can result in a real mess for parties and for tribunals. And I would really encourage parties thinking about contract provisions to think about that in some detail and ways to mitigate that risk, because it really can become a horror show, and it can make a commercial process needlessly antagonistic and costly. And then I think, if you already have an arbitration provision and you can't go amend, the price review clause or the arbitration or dispute resolution provisions in your agreement, it's still worth noting, and I think Stephen mentioned this, that commercial discussions can be ongoing. Parties can always take a moment to say, hey, time out. Do we really want to go down this road? Let's think commercially about this. Let's put our cards on the table. I think sophisticated arbitration counsel will always encourage that throughout the process. And, sometimes it's up to the clients to say, yeah, we really want to do that. And in my experience, and as Stephen mentioned earlier, many of these disputes settle once the cards are out on the table and people realize the risks of having an arbitral tribunal make a massive zero-sum award one way or the other as the final outcome. People get a little gun shy, shall we say, at the end of the arbitration proceedings. So, to the extent that we can think about that in advance and avoid those risks, I think that's to be preferred all the way around. But I open up the floor for comment to my colleagues who may have different views.
Let me just expand a little bit on some of that. I do think institutionalization of arbitration reflects a bureaucratic concern, and when we realize the significance of these contracts, the values, the importance for the companies, I think what has happened over time, once Europe shifted to saying let's arbitrate some of these, and people started to realize how that worked, the more, I hate to say it in these crude terms, but the more junior people, the sort of the line management type started to say, I don't want to be responsible for compromising, reaching an agreement on something so important to the company, and therefore we use arbitration. So we start using arbitration, and why you see settlement eventually is that you see, as you say, as William says, put the cards on the table. But at some point, senior management has to step in and say, okay, we've spent a lot of money. We're now about to turn this over to 3 lawyers who, they may have seen this sort of stuff before, they may not, but they're going to decide our price formula and our long-term contract. And that's when the settlement happens. So it's sort of by design forcing the most senior decision makers to step in late. So one of the issues then we're both talking about is how do you get that sort of focus earlier? And one of the problems we also see, and again, it's this bureaucratic imperative, is a fear to change price review clauses, right? I have seen parties use the same bad price review clauses that they recognize as bad, that they grumble themselves about. I don't know what this phrase means, or this phrase has led to so many complications in price reviews and in arbitrations, but I don't want to fix it because I'm scared to change it. So there's a real obstacle to overcome with that. So that's the hurdle we're facing. But let's then also briefly talk about the solutions. I don't think speeding up is the solution. I'll say 2 things. We've ended up in arbitration in part because that's turned out to be better than litigation. That's turned out to be better than expert determination, often in part because there's not enough experts. You can't hire a Christian to be your expert because he's too involved in these. He's got too much background in this. So there's a handful at best of competent experts, and reaching agreement on them is really tough. So there's that problem with expert determination. But speeding up has its own problem. I have been in lots of cases where the contract says 6 months, a price review clause, arbitration, 6 months, and both parties, and that's been in place for 30 years. And suddenly they finally, after 25 years of that contract's existence, they suddenly have an arbitration, and they go, wow, there's no way we can do this in this time frame because it's so expert intensive, it's so data intensive, and we're only getting our heads around it. So speeding up the arbitration itself becomes quite difficult, and the reality of how parties deal with it once they're faced with an actual arbitration tells you there's issues there. So where do you speed up, and how do you fix these problems? And I think it's some of what William talked about. It's that first stage, that make a substantiated price review that requires you, again, the bureaucratic imperative is to hold back as much information as possible. If you think you're going to arbitration, you don't give all your information to the other side because you think, I give them a head start, they're never going to agree, or I only leak it into the discussions if I think we're making progress, but otherwise I hold it back. Then we have a price review, arbitration commence, and then we're starting from scratch and really formulating our cases now. So the more the clauses say you really do have to bring your substantiated positions forward during that 6 months of discussion and through your price review process, and maybe say you can't then expand your case if you do go to arbitration, so live with it. We'll put pressure not just on the parties to front load their disputes, but we'll perhaps force the senior people who really have to make the decisions into the conversation. It will force Christian into the conversation. It'll force you to go get those experts in a way that parties, for their own bureaucratic reasons, again, often hold back spending that money on an expert until you actually have an arbitration. And frankly, sometimes it fell well into the arbitration. And so it just forces everyone then to come to the table in a much more meaningful way. And that's where I think the idea of it, maybe using an expert in a sort of a mediation kind of way, or an actual mediation, might be a way to break the logjam. Then once, if you really make that first stage meaningful in a way that's lost meaning in Europe, at least, because everyone holds back. And if they're having a more packaged overall discussion of renegotiating the entire contract, changing other terms, sometimes you get solutions in that window. And frankly, that 6 months is often extended and extended and extended, again, showing the speed up in part isn't the arbitration, it's the pre-arbitration phase that causes it. But I think making that phase meaningful is the only real way I can see to solving this. And that takes some guts by the parties to stand up and say, the ones who've got experience with it, to say, we don't like this ourselves, and so here, how do we fix it? And the ones who are coming into it new, saying, I've heard these horror stories. Can we do something to make this process work better? And it does knock William and me out of it, and Erdem out of it, but we'll have other things to do, and maybe we can help in that negotiation phase. But frankly, I'd rather have these things solved efficiently, because it hurts all of us to have money wasted and time wasted on something as important as energy supply disputes. And so that's my thoughts on how you might solve some of these issues.
On a similar note to mediation, Steve and William, I'd ask you to what extent do you think it would be useful to have party-appointed experts meeting quite early in the process? Because certainly in my experience, the moment you're face-to-face or email to email, however it's working with another expert, the areas of agreement are suddenly much larger than they are otherwise. And
it's more meaningful if you have those experts up to speed, right? So you really know what the issues are, so you spend some time with it. And so that means that, again, front loading the investment on information on figuring out the real case by the parties to get to use something like that. And I agree with you. That's part of what I envision as that in that early window to try to solve the problem.
Yeah, to piggyback on that, I agree with both of those things. I think the one contractual tweak that you could make to that is really the notice requirements for triggering a price review, for noticing the other party. You could, it's sometimes embarrassing to see what qualifies as a notification of a price review. A 2-page letter saying, here are the circumstances, there's been a change, and here's my new price, take it or leave it. And more substantial data in support of that initial notification would be welcome.
And let me illustrate that too, because I have had so many cases where there's been a fight about whether the parties are allowed to go past something that was said in that 2-page or 1-page or 4-page letter, and whether what they're doing and whether they're allowed to expand that in the arbitration, and frankly, whether they are expanding it, whether that cryptic 2 pages includes the concept,
yeah.
But also whether there's a legal requirement that they get that all in, and who's sending those letters. I would say, in my experience, nearly 100% of the time, that letter is being sent in a second language by line managers in those companies, and a lawyer hasn't seen that, or if it is, it's an in-house lawyer who doesn't understand this process, again, operating in a second language, because this is all happening in English, and the one side might be speaking Russian and the other side might be speaking Turkish, and yet someone writes a very cryptic 2-page letter that is the heart of all this, and that also leads to sort of distractions, arguments, digressions that slow some of the stuff down. And in the arbitration, then we're arguing not only about the merits, but whether or not there's a procedural bar to what you're talking about. But the real point is to say, the more focused you are on what your case is and communicating that early and in detail, you solve both the procedural and the substantive issues, I think.
Yeah, I can just add a few things to what you said, that in my practice in Botaş, I spent 18 years. So I signed several price revision request letters, especially to the Russians, Gazprom. We didn't went to the arbitration at that time, but Russians accepted for the review of the price, and we, after a long negotiations, agreed to a new price formula. But you're right, the lawyer didn't see all those letters, because at that time there was not any lawyer knowledgeable about the natural gas contracts in the 80s. But Russians accepted the price review. That's why we didn't go to arbitration.
And I should say, I mean, this coming back to this idea of institutionalization, I have seen contracts where the parties worked it out. There was 19 scheduled price reviews opportunities, and they worked it out every single time. Either no one raised a price review, or someone put in a notice, they worked it out. That was until we got to about 2010, 2015, where those same parties now arbitrate every single time. And so that sea change in culture is part of this institutionalization we've been talking about. I don't want to trivialize it. It's not just bureaucracy. It's not just people being afraid to take decisions. It also was the massive changes in the European market in particular that is happening simultaneously. But that the knock-on effect has been since then, it's been hard to put that genie back in the bottle.
Yeah, but just to add one more thing, during the preparation of the sales and purchase agreements and negotiations, we took advice, mostly from British Gas, and their lawyers advised us during the 1983-84.
Yep.
So I mean, these are extremely interesting. Salih Bey, do we have any questions from the audience? So okay, we have 5 more minutes. Maybe I can ask one question. Have you ever seen any case where parties arbitrated under the same gas price review clause for more than one time, and and in those cases, how did the arbitrators approach the question whether the previous award can be submitted and accepted as an evidence in the next arbitration?
Yeah,
because parties are the same, the clause are the same, the issue is the same, but at the end of the day, there are 2 separate and independent maybe arbitrations.
This is a brilliant question. It may be one of the issues that we can fix in revising new or drafting new arbitration clauses. I've seen that multiple times. There isn't a clean answer. It often is considered not res judicata or estoppel. Some tribunals will say, well, there's already been a decision, I've got to take that as now the established practice or the answer, and others have said, sorry, starting over. And it does create a mess. And actually, Christian and I were in a case once where we had a second arbitration after the first, and the other side insisted that the first award was meaningless and couldn't be considered by the tribunal. And yeah, it is a really vexing issue. We haven't talked about governing laws, but the law that would answer that question is the issue of estoppel and res judicata and things like that is complex, including what law you look to. Do you look to the law of the contract? Do you look to the law of the seat? But in many places, it's hard to argue that those doctrines apply, and you end up with something that seems absolutely bizarre, that the parties could have regulated their pricing through one arbitration, and that is not taken into account under the same contract in a subsequent arbitration. And obviously, if you don't like the earlier award, you kind of like that in the moment, but as a matter of the way to regulate a high value, important long-term contract, that doesn't make a lot of sense.
Mm-hmm. From a market perspective, it leads to some really interesting issues as well, because one of the obvious properties of a market change is it doesn't stop on the price review date. The effects of market changes continue over time. And so one of the big arguments we have as experts is, to what extent did a previous market change get taken into account in an award, and how much of it can we take into account in the current arbitration? And that can be a very, very complicated question to answer, even ignoring all of the legal issues which Stephen's just alluded to. So it creates all sorts of interesting economic questions as well about market change.
I would echo all those comments. I would also say that one of the key issues there is the composition of the tribunals, right? So you can, it's unique because you don't have oftentimes there may be a written award, but the people deciding the issue the second time may be different than the people who decided it the first time, which can introduce its own complexities. And just by way of anecdotal experience, I was in a series of 3 price reviews, right, where the tribunals who considered the first 2 price reviews were the same, and the tribunal that considered the same price review provision, the same contract, everything, the third time came to a completely different result than the first 2 tribunals. So tribunal composition really matters quite a bit, I would say.
Is there any way to mitigate this while drafting the clause?
I think the answer is there may be, and it's something that needs to be thought about. And I don't know that people have thought about it very much. I mean, it comes up occasionally now at conferences, but I haven't seen anyone actually try. In part, it goes back to the conservatism about changing these clauses, but it's not necessarily obvious how you do it, but it's also not necessarily obvious that it's hard to do. I mean, you could say that, you know, a previous award is binding and must be taken into account. Part of the problem here is then something that William just raised, which is, and I guess I alluded to it earlier with when you get to settlements, it is the tribunals. We have now increasingly sophisticated arbitrators who have seen price reviews repeatedly and therefore have a sense of them, but you still have lawyers writing something that's commercial and economic and complex. And therefore they may draft it in a way that is driven by their own imperatives and not in a way that's useful to the parties. And they're not thinking about the second price review or the fifth price review afterwards. And so you often end up with awards that are a bit puzzling, which is one of the big drivers around settling just pre-award. And frankly, tribunals need to be more aware of that. And another thing you could think about putting into the contract, or certainly into a procedural order if you end up in arbitration, is something that says, if you get to a point where the tribunal is about to issue its final award, they need to give the parties a chance to talk first, because that's the sweet spot where you can get that final settlement. And I have seen tribunals suddenly drop an award out of the sky on parties who were in settlement negotiations, because these are ongoing relationships, right? So the parties are constantly talking and trying to solve these problems, and suddenly suddenly the award shows up and destroys what would have been a better solution. So that's another thing to think about, is the conduct of the tribunal and its awareness of its impact on the parties, both through things like how will this be used in the future, and also, you know, should the parties be given an opportunity to get one last chance to fix this between themselves before we drop something on them.
Yeah, and to that end, I think you know, bifurcation is time consuming and perhaps not super effective, but that is an advantage of bifurcation, right? If you bifurcate the issues of need to revise and how the formula should be revised, it allows the tribunal to give the parties some guidance about where this thing is headed and give them an opportunity to negotiate something workable. Because the worst case consequences, you know, I think the most famous instance is the Atlantic LNG case, right, where the tribunal came up with a price formula at the end of that no party had proposed and no one really thought was workable, and the parties immediately renegotiated it. So, you know, I think, you know, that is a huge risk, and you know, I think Stephen's point's well taken, that there are, I would say today, in part because of the institutionalization of price reviews, there's way more sophisticated. There are way more sophisticated candidates for arbitrators who really understand these issues now, and so perhaps there's more conservatism and more understanding there. But it's still a risk to be mitigated. Perfect.
So Gökhan Bey, William, Steve, Christian, thanks a lot for accepting my invitation to this panel. It means a lot to me and this firm. And so our time is up, and we have no more questions. And okay, we are ready to end the session. Thank you.
Thank you so much.
Thank you, Erdem.
Thank you. Thank you.
Thank you.